Philippine Telegraph and Telephone Company vs. NLRC, GR. Number 118978. May 23, 1997. Facts: Grace de Guzman was initially hired by petitioner as a reliever, specifically as a supernumerary project worker, for a fixed period from November 21, 1990 until April 20, 1991. Vice 1 cf. Tenorio, who went on maternity leave. Under the reliever agreement which she signed with petitioner company, her employment was to be immediately terminated upon expiration of the agreed period. Thereafter, from June 10, 1991 to July 1, 1991, and from July 19, 1991 to August 8, 1991, private respondents' services as reliever were again engaged by petitioner, this time in replacement of one Erlinda F. Dizin, who went on leave during both periods. After August 8, 1991, and pursuant to the reliever agreement, her services were terminated. On September 2, 1991, private respondent was once more asked to join petitioner company as a probationary employee, the probationary period to cover 150 days. In the job application form that was furnished her to be filled up for the purpose, she indicated in the portion for civil status therein that she was single, although she had contracted marriage a few months earlier, that is, on May 26, 1991. It now appears that private respondent had made the same representation in the two successive reliever agreements which she signed on June 10, 1991 and July 8, 1991. When petitioner supposedly learned about the same later, its branch supervisor in Baguio City, Delia M. official, sent to private respondent a memorandum dated January 15, 1992 requiring her to explain the discrepancy. In that memorandum, she was reminded about the company's policy of not accepting married women for employment. In her reply letter dated January 17, 1992, private respondent stated that she was not aware of PT&T's policy regarding married women at the time, and that all along she had not deliberately hidden her true civil status. Petitioner nonetheless remained unconvinced by her explanations. Private respondent was dismissed from the company effective January 29, 1992, which she readily contested by initiating a complaint for illegal dismissal, coupled with a claim for non-payment of cost of living allowances, COLA, before the Regional Arbitration Branch of the National Labor Relations Commission in Baguio City. Labor arbiter held that private respondent, who had already gained the status of a regular employee, was illegally dismissed by petitioner. NLRC upheld the labor arbiter. Seeking relief through the extraordinary writ of certiorari, petitioner Philippine Telegraph and Telephone Company, PT&T, invokes the alleged concealment of civil status and defalcation of company funds as grounds to terminate the services of an employee. Issue: whether the concealment of civil status ground to terminate the services of an employee. Held: no. Corrective labor and social laws on gender inequality have emerged with more frequency in the years since the Labor Code was enacted on May 1, 1974 as Presidential Decree No. 442, largely due to our country's commitment as a signatory to the United Nations Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW. Principal among these laws are Republic Act No. 6727, which explicitly prohibits discrimination against women with respect to terms and conditions of employment, promotion, and training opportunities. Republic Act No. 6955, which bans the mail-order bride practice for a fee and the export of female labor to countries that cannot guarantee protection to the rights of women workers. Republic Act No. 7192, also known as the Women in Development and Nation Building Act, which affords women equal opportunities with men to act and to enter into contracts, and for appointment, admission, training, graduation, and commissioning in all military or similar schools of the Armed Forces of the Philippines and the Philippine National Police Republic Act No. 7322 increasing the maternity benefits granted to women in the private sector, Republic Act No. 7877 which outlaws and punishes sexual harassment in the workplace and in the education and training environment, and Republic Act No. 8042. Or the Migrant Workers and Overseas Filipinos Act of 1995, which prescribes as a matter of policy, inter alia, the deployment of migrant workers, with emphasis on women, only in countries where their rights are secure. Likewise, it would not be amiss to point out that in the Family Code, women's rights in the field of civil law have been greatly enhanced and expanded. In the Labor Code, provisions governing the rights of women workers are found in Articles 130 to 138 thereof. Article 130 involves the right against particular kinds of night work, while Article 132 ensures the right of women to be provided with facilities and standards which the Secretary of Labor may establish to ensure their health and safety. For purposes of labor and social legislation, a woman working in a nightclub, cocktail lounge, massage clinic, bar or other similar establishments shall be considered as an employee under Article 138. Article 135, on the other hand, recognizes a woman's right against discrimination with respect to terms and conditions of employment on account simply of sex. Finally, and this brings us to the issue at hand, Article 136 explicitly prohibits discrimination merely by reason of the marriage of a female employee. Parenthetically, the Civil Code provisions on the contract of labor state that the relations between the parties, that is, of capital and labor, are not merely contractual, impressed as they are with so much public interest that the same should yield to the common good. It goes on to intone that neither capital nor labor should visit acts of oppression against the other, nor impair the interest or convenience of the public. In the final reckoning, the danger of just such a policy against marriage followed by petitioner PTT is that it strikes at the very essence, ideals and purpose of marriage as an inviolable social institution and, ultimately, of the family as the foundation of the nation. That it must be effectively interdicted here in all its indirect, disguised or dissembled forms as discriminatory conduct derogatory of the laws of the land is not only in order but imperatively required.